Okay, gachtainna tá fáilte go léir rasar maidin, agus tásúlacham go bhain gachtainna tainmh as an maidin a bhí agan as maidin a bhí agan chomh. So, I just want to welcome everybody back here, agus gachtainna tá Arlena new freshen. I'm delighted to be chairing this session, the chairing on the importance of advanced planning and looking at on this session on planning ahead to preserve your will and preference. And we have some terrific speakers and a very good panel with us today. We're going to get started with Anya Flynn, who needs absolutely no introduction, having already spoken to us this morning and last night. And just to say, during the session, we will have an opportunity for Q&A at the end. And briefly to introduce myself, my name is Siobhan Ivrian. I'm the HSE's National Clinical Director for Integrated Care, which basically means I look after the national clinical programmes. But in my clinical background, I'm a consultant psychiatrist for older people's care, so I have a very long-standing interest in this whole area of care, assisted decision-making and supporting people in understanding and working with their will and preference. So on that note, I'm going to welcome Anya back to talk to us about enduring power of attorney. Anya, the floor is yours.
Yes, enduring powers of attorney. So in 20 minutes, it's not going to be possible to do a full walk through everything that enduring powers of attorney involve, but I hope to cover some of the main issues which we've seen arise in this really important part of the Act and to point you towards further resources. Why plan ahead? I think we have heard the message, I hope loud and clear today, that next of kin doesn't actually mean anything, but I do have a Cork-related story. I was speaking about this time last year to Rehab Community Services here in Cork to an audience of young people with an intellectual disability. I've told this anecdote before, but I did say, as I often do, who knows what next of kin really means? And a young man with ID shouted from the floor, "It means you're dead," which was pretty well on the money. We're going to put it on a poster. He said it in a brilliant Cork accent, which I won't imitate, or you would definitely come for me. But yeah. We all know it. Next of kin doesn't mean anything. Plan ahead to ensure that your wishes are always understood and respected. And one way of doing so is by way of the enduring power of attorney. That's Helen Rochford Brennan from our public information campaign of last year, a very impressive disability and dementia activist who speaks very impressively and persuasively about the importance of accessing tools for advanced planning. Enduring powers of attorney. So there have been statutory changes. I will remind you the Decision Support Service did not write the Act. We are creatures of the Act. We have to deliver a process that matches the statutory requirements of the Act. And I suppose where that has become challenging is that there was a way of doing it before. There was a way of doing it before which has changed, not in every way, but in some important procedural ways, and the requirements of the Act therefore have to be built into a process, and that was the motivation of the Decision Support Service, or the obligation of the Decision Support Service. So just a couple of basics. Maybe just to state the very basic matters in terminology, when you make an EPA, you're fine. You're fine and your capacity is not in question. You're planning for a time when you may not have that decision-making capacity to make the decisions which you're going to cover off in your enduring power of attorney. When you're doing that, you're called the donor, the person that you know and trust who's going to make those decisions for you. Should the need arise, should it arise in the future, is called your attorney, or attorneys, plural. You can name more than one. So attorney in that sense, it's a bit of an archaism. It does not mean lawyer. And the EPAs have been around since the Powers of Attorney Act of 1996, and if anybody made their EPA before the 26th of April last year, they were doing so under the 1996 Act, and that EPA is still valid. All of the old processes about registering that EPA in court at the point of need continue to apply. The DSS is not involved. Early on, and maybe just occasionally still, we get asked about the court process for registration under the old Act. Very early on, people were sending us their 1996 Act EPAs. We don't have a function in that regard. There's a section of the Act as yet uncommenced which said that we could perhaps establish a register of those older EPAs, but that's not with us as a function. Our only interaction, in fact, is that we can take complaints about attorneys under the former Act, and that's actually where we've been busiest, with still the majority of our complaints being about attorneys appointed under the old Act. I include here, but it isn't a change, it was always true that an EPA could never grant authority in respect of treatment decisions, frequently misunderstood, I think. So what the 2015 Act has done is to introduce a two-step process, so that now when you create, execute your EPA, it's sent to us, to the Decision Support Service, for review, and that follows a process, and then for registration on our registers, that people have, I hope, the comfort of knowing that that has been reviewed, that the DSS has satisfied itself that this is a document which will work into the future, and it's in a place. People know where it is, and it may never, and the hope is that it is never called into action. So the second step then is that stage when it is notified to us. So the phrases now are the phraseology now is registration and notification. Notification being that second step when the donor has lost capacity and the attorney needs to let us know that they need to step up and carry out their decision-making duties under the Act. What is also new is that the capacity statement, which are required at different junctures, may now be supplied by a medical or other healthcare professional. That same list that I mentioned earlier in respect of CDMAs and the training, which I pointed some of you towards earlier in my earlier slides, again, covers off Part 7 of the Act and EPAs. And also, I mentioned the significance of safeguarding. Safeguarding is a mandate of UNCRPD when it comes to decision support arrangements. One aspect of it is there are new supervision and reporting duties, so that an attorney who has stepped up post-notification and become the decision maker comes under the supervision of the DSS with reporting duties quite similar to those of the court-appointed DMR. And of course, the attorney, as an intervener under this Act, is applying the guiding principles of this Act, giving effect insofar as practicable to past and present will and preferences. Our digital first approach is much talked about, and our Chief Executive John Farrelly referred to it yesterday. So the motivations of that digital first approach are to help promote efficient delivery of the service across all of our functions. I described the range of our functions to you earlier. So registration is only one of them. Registering EPAs that we're talking about here is only one of those functions. And the digital first approach has been arrived at with consideration. It's based on government policy, and that government policy is there for a reason. A digital approach, and this may not be intuitive, I suppose, to everybody, comes with much greater security in terms of data than a manual or paper-based approach. It's evidently more efficient. If somebody is using a manual approach, and we do facilitate it, more of that anon, then there are steps that we need to replicate offline to mirror what somebody has done online, because after all, you're putting this on a register. That register isn't a big red book. It is a digital register, and would have to be when you think about scalability and volumes. With a digital first approach, there is a significant reduction in the rate of error. In our manual EPAs that come to us, we have seen a 50% plus error rate. Whoever is sending them to us, it tends to hold at about 50%. And sustainability is a valid consideration as well. There was an alarming day last summer when I think we were photocopying 900 pages a day and thinking this is not what we were set up to do. And more about our accessibility policy on the next slide. And this is all based on good learning from other jurisdictions. Last week, my colleagues and some other colleagues from Ireland were at the Four Jurisdictions Conference in Edinburgh, where a lot of the agenda was taken up with the promotion of a digital first approach. Their systems are a generation old in England and Wales and in Birmingham, and they are still very much tied to paper, to their cost, including the cost of reinforcing floors. All of this obviously has been through data protection with the Data Protection Commissioner, and we have run a data protection impact assessment which is kept up to date and under review. We are supported in being able to have a digital first approach because of the language, the amended language of the Act itself. The Act, before it was amended, read in quite an analogue way. It seemed to picture paper forms and big red books. But now we have with 95B the provision that the Director may specify that a document, and they're broadly defined, can be in an electronic format, that we are authorised to say the circumstances in which that specification for electronic shall or shall not apply, and we can certify, importantly, the electronic copy as being a true copy. Other jurisdictions are still, under their Act, very much wedded to paper and ink. And through this digital first approach, an applicant is therefore able to open a secure, authenticated portal account to complete unique forms pre-filled with their information, to access supporting documents, to upload and to submit for registration. Not as straightforward as I know I've just recited it there. This needs a bit of thought and very much an approach that is support-based, which is what we aim to deliver. We're not digital only. So an alternative manual process for all of our applications, but I know we're speaking here about EPAs, has been available since commencement, and that led to quite the influx of paper we needed to take corrective action if we were to continue to deliver across all of our services. It was with that in mind, and after quite a bit of back and forth and a lot of really good input, including from our stakeholder forum, that we adopted an accessibility policy in July of this year, the purposes of which are to assist those who are not able to use the online portal with access to appropriate supports or alternative formats. Paper, let me say, is not particularly accessible. Editable PDFs are not accessible documents. And we have done an accessibility rating of the forms that we've created. Always room for improvement, but there can sometimes be a default to assume that paper is your friend when frequently that's not the case. And also to ensure that resources are targeted to provide appropriate individualised support and to promote the efficient operation of the service for all users. So in effect, where somebody is unable to use the portal for whatever reason, should that be due to digital literacy, connectivity, other issues which might include a disability, in which case you may be contacting our access officer, but again, we want to make that a plain path. And if they cannot reasonably be supported to use our systems, either by the DSS, and we'll be first up, by a professional or by another person, then they can be facilitated with the alternative manual process. And the adoption of that has had a kind of resetting, recalibrating effect, so that to date, on my stats, I'm assured by my team here before me here, are good as of yesterday. We've had 38 submitted requests for a route towards the manual system. Of which to date we have issued 19 manual forms, and we're still dealing with 10 and dealing with those within the timeframes which we have set for ourselves. So getting on to the MyDSS portal, why have we done it this way? We're creating an account for every person using the DSS services so that we know who we're interacting with. I've spoken about security, about the importance of establishing identity. We don't get to meet these people. They're putting in place important, really significant legal arrangements, so we need to know who we're speaking to. It's again part of the safeguarding aspect of the Act. So identity verification is the first step of the process for all of our DSS services, and identity verification can be completed on the portal via our website. Most accounts, and I'll come to MyGov now, have been opened with a fully verified MyGov ID account. An alternative is available. An alternative to MyGov has been available from the start. But then again, that secure MyDSS portal account routed, and the route to it is either via MyGov, or the alternative ID verification is allowing people to create those unique forms, access their documents, and then to upload and submit. And we have, as of, I think yesterday, probably slightly more than this now, but we have over 19,000 verified MyDSS accounts. MyGov. MyGov will be familiar to many of you. It's a single login for many and a growing number of government services in Ireland. It was probably still an air of novelty when we adopted it as our unique identifier, but has become much more embedded, so that 2.3 million adults in Ireland have verified MyGov ID, including, and 38% of that number are those over 70. Sorry, 38% of people have MyGov ID over 70. Ian will tell me if I'm wrong about that or misusing the 38%, but it's very much with us and it's growing. And people who have a public services card, which can include their free travel card, are MyGov ready, and it's a relatively simple process to go from having a public services card to having fully verified MyGov. I will be bombarding you with stats, but over 13,000, that's over 13,500, or over 71% of our fully verified MyDSS accounts have been opened with MyGov. And of that number, close to 9,000 now are MyDSS account holders who are aged over 70. Over 57% of those aged over 70 have used MyGov to open their accounts. Do I have to have MyGov? You do not have to have MyGov. I've read in several places and quite recently that we insist on MyGov, and we don't. So an alternative process for ID verification has been available from the start. It's accessible via our website, and that alternative manual way of verifying your ID is something which we now aim to do. Ian will rise up if I got this wrong. We're doing that within about a week now, aren't we, where our timelines used to be much longer. So whether you open your account with us with manual or using MyGov, which is instantaneous, you have access to the platform in exactly the same way. Solicitors instructed by a donor to create an EPA. So if a donor is instructing a solicitor to make and to register the EPA, the whole end-to-end process, then that solicitor, of course, may be recorded as an authorised contact for the application, and then we speak to the solicitor. Helpfully, and we have had a lot of engagement with the Law Society through last year into this year, the Law Society, in its practice note of the 15th of February, confirmed that there's no prohibition, whether in the Act or the processes, on that practitioner who's assisting their client to navigate the portal to work with the portal, and they're doing so. They're absolutely doing so. Legal aid, incidentally, and I know the Legal Aid Board is here today, is available for EPA applications, something which perhaps isn't accessed as often as it might be. That is the application process, or at least that's how you get into it. I don't have all of the steps, but there are a range of resources on our website, and I'll point them to you, but that's what you would see first, where you're able to locate that an EPA is the one that you want to make. And that, in step form, are the steps in the process: creating, filling in, signing the documents, uploading. There's a notice requirement. I'll say a bit more about what the Act has to say about that. Paying your €30 registration fee to the DSS, and do remember to hit send. And then we have that function to review and to make a decision about whether or not to register it during, and we pick that up after the 5 weeks notice period has elapsed. And I set out here the accompanying supporting documents. Signing and witnessing, this comes up a bit in discussion. I'm speaking here about things that the Act says, and this is a point of pain, I know, for people, and I'm sympathetic to it, because the Act requires that the signing and witnessing of the EPA takes place with everybody together in a real place. The donor, the attorney or attorneys plural, their witnesses. And we have had people say to us, but I really want to make an EPA. I'm here, and the people that I want to name as my attorneys are in Singapore and Australia. I am very sympathetic, and particularly since we are digital first, to the idea that with some imagination, that doesn't need to be happening in a room with literally 4 walls. So I hope that that's something that might be revisited, but we've taken an interpretation on it from the department, I think from the AG's office as well, and regrettably that means in the actual presence of, it's replicated throughout the Act. And do bear in mind the requirements of those witnesses, that they are adults, one at least is not a family member, and if a solicitor is witnessing it, don't be a solicitor on record for the attorney, because that's an exclusion. The statement by the legal practitioner, there's a Law Society guidance note on that as well, is very similar to the legal practitioner statement under the old Act. So this lawyer, who can be a solicitor or a barrister, is saying that they are satisfied the donor understands, satisfied they're aware that they can vary or revoke their EPA, and then a different standard has no reason to believe they're acting subject to fraud, coercion or undue pressure. I think it's important, though, to say that this statement is now located in a different layer within the Act, so that previously, arguably, the solicitor who signed such a statement under the old Act was theirs were the last eyes on the document. Now it comes to us for review with the opportunity for notice parties to object. Very few have, I think, to date. And we're reviewing it to make sure that it's compliant with the Act. It's a supervised arrangement when it comes into effect at a later time as well. So not as much, I would submit, hangs on that statement as was true under the previous Act. But that's probably a further conversation. The statement of capacity by the medical or other healthcare professional, I will say no more other than to make sure that that is completed after the person has executed the EPA. It isn't permission to make an EPA, and it's important that it postdates execution, because you're saying, I have discussed the implications and I'm of the opinion at the time that the power was executed, the donor had capacity to do so. So getting it in the right order is important. We review it, as I've said. There are detailed criteria in Section 69 before it makes it on to the books of the DSS, and the named notice parties are able to venture objections, not something that's been happening with any regularity. And it's also, I think, the case that out of the EPAs that we've registered to date, we've only had to decline to register fewer than 5. One, because it looked nothing like an EPA at all. It was quite an adventurous document. And in other cases, we were embarking in that process of engagement to get it fixed. And I think in some cases, their plans changed, or in any event, we didn't hear further from them. That is an appealable decision, but as I say, refusals have been minimal. The discretion in relation to notice requirements, and there's a second discretion here. We have a discretion. I don't think we've had to maybe exercise it once. So if reasonable efforts have been made to satisfy the notice requirements, we can treat the notice requirements as having been met. This one tends to come up a bit as well. Limitations around varying your EPA. Again, we've discretion to allow people to vary their EPAs, and they may well need to, earlier or more frequently than the time limits set out in the Act. Nobody's asked us to do so yet. The new supervision and reporting requirements, I won't labour, but the attorney now has that function to submit requirement to submit the reports within 3 months in respect of assets and liabilities if they're dealing with property and affairs decisions, and also to keep their accounts and records and then the reporting annually. If the reporting is incomplete, we may need to determine that they can no longer act, and that becomes appealable to the court. Again, not something that we've had to do, and we do have that function, ability to investigate complaints. Numbers, people love numbers. So as of yesterday, we have now fully registered 1,287 EPAs. So they are over the line, review has happened, notice periods have expired, they're on the books. About 900 of them having made it past the registration point since July of last year when we made the accessibility policy operational. There are more again, over 1,400 which are submitted, job done, pending review and registration, no reason to think that they won't also be registered. I mentioned the definition of active earlier, so we have over 4,800 active applications, meaning that the intending donor has completed the instrument and has moved to accessing the supporting documentation, and that's a subset of a bigger pool of over 9,600, close to 9,700 draft applications at earlier stages. From what we can see, solicitors are instructed in the making of EPAs in approximately 27% of applications when we look at all stages, and 98% of EPAs that have come our way are a grant of a general authority, a relatively simple, though nonetheless very important document. We have a help desk. Thank you. We have a help desk, and this is the help desk on the road. I didn't tell Aoife I was going to use her lovely photograph. But this is an initiative that we have hit upon lately to try and get the word out there better, and perhaps countering some level of misinformation, misunderstanding, apprehension that this is all woefully complicated and cannot be done, because I think the numbers show that it can, and they're increasing all the time at all stages. So we trialled it in Galway, and no coincidence that Aoife is from Galway. Meeting people, meeting solicitors as well. We invited them to come in, bring their cases, let us see if we can help if they seem to be stuck. That was, I think, a very useful event. We were delighted that it went so well, and we hope to do more of it. Next destination might be Cork. So we hope that that is something that an offer that people would take us up on. And we're also, and I know that they're in the room today, collaborating with the Irish Hospice Foundation, with Age Friendly Ireland, again, promoting the theme of advanced planning. I spoke about this earlier. So we've been to Cavan, 3 different locations in Galway, and we've been to Kinsale, so more of that to follow. Advanced planning will be the theme of it's out already, isn't it, of our public information campaign, getting away, I hope, from the idea that making an EPA is something you do late in life, something that is very postponable, or that they are the territory of the elderly, or much worse, when capacity is already a live issue. The best time to make an EPA if you don't have one is always right now. But we do hope that people embrace the idea that you do it when there isn't a component of stress involved in it, that you do it at a time when you're able to take time over making sure it's the document that you want, and then it's done, possibly never ever to need to be called into action. Those are some of the resources which may be difficult to see there, but they include access to, we have a lot of materials that are there, and we hope that they're useful, including a step-by-step, screen-by-screen video, series of videos, again featuring Aoife, who is here today with us. And our help desk has been operational for a few months now, gaining in their own expertise. This is new stuff, new service, new staff. And I know we can only beg your indulgence for so long, but they are getting really, really good at helping people in that practical way about making their EPAs, including in those circumstances of pressure, which we hope can be avoided. And I will finish with this, Elaine, I promise. Last week before last, we got a call on a Wednesday afternoon to say, my husband is having brain surgery on Friday. They had an EPA with our assistance by Thursday evening. We also got a call from a solicitor to say, I have to get to Dublin tomorrow because I have clients who are up there who want to make an EPA. Again, we were able to assist. Call us, please. We will help you. We will help your solicitor if you've instructed a solicitor. You want them to have an EPA. They want to have an EPA. We want them to have an EPA. So thank you very much for listening to me. Happy to take your questions.
So that was absolutely fantastic on your whistle-top tour of how to start getting going on making an EPA. And the take-home message for me from that is, I need to get started on my own EPA. So that's my homework for the next couple of weeks. I'm delighted now to welcome a newish person to my life, in that I'm getting to know her much better, but somebody whose career I've been following with interest for a good number of years, and that's Patricia Rickard-Clarke, who's a former chair of the Law Reform Commission and currently chair of Safeguarding Ireland. Patricia has been tireless in her advocacy for human rights and for bringing this into our consciousness and thinking. And Patricia's going to talk to us now about planning ahead and advanced healthcare directives. Patricia, thank you.
Good morning, everybody, and I'm delighted to be here. I'm going to emphasise really some really important issues about recognising rights and making sure they're implemented. So just to say that we have a rights-based approach now, ensuring the rights are respected, including the right to autonomy, respect to dignity, bodily integrity, privacy, control over financial affairs and property, equal treatment in respect of access to goods and services, and respect for beliefs and values. And just to emphasise, somebody mentioned earlier about the right to inherit under a will, or right to inherit property. That's one of the rights in the legislation. It's actually a constitutional right. And in the Property and Affairs decision, a person that you appoint as your decision maker has the authority, you can give them the authority to make a claim to make sure that a person who's entitled to an inheritance gets it, or makes a claim against a person's estate, or makes a claim against the estate of a deceased partner, spouse, or civil partner. So really important issues that really haven't surfaced yet, but I see through SAGE advocacy a lot of these issues are arising. Again, just to say, I was in court at the very early stages of the commencement of the Act, and there was an application, solicitor barrister representing a family. The family were there, and the barrister stood up and said, "Judge, I'm here representing the family. Their father is in a nursing home. He's made a will. He's left his property to the family, and the family now wish to sell the property." And the judge, who's present here today, said, well, your father isn't dead yet. So that's the sole custom and practice that we have to move away from, and respect really the rights of very vulnerable people, or people at risk. So the Assisted Decision-Making Capacity Act actually has 9 guiding principles. Again, just to emphasise the presumption of capacity, giving effect to the will and preference of the person, and actually arrangements to support that person. The optional protocol has been mentioned a few times in the last night and today. The optional protocol is going to actually hold people accountable to say what support have they given a person. So that's really, really important. And hopefully the Irish Human Rights Commission and other organisations will be assisting person to actually make people accountable and asking questions about the support that they were given. So really important. The Law Reform Commission then, again, in their regulatory framework on adult safeguarding, which was published in April of this year, has 7 guiding principles. And again, replicating what the Assisted Decision-Making Capacity Act, the UNCRPD gives, and again, the presumption of capacity, facilitation and supported decision-making, ensuring informed consent, and ensuring the respect for will and preferences. So safeguarding, of course, is much wider. It covers a much wider group of people than people whose capacity has issues. It covers people who are at risk for various circumstances, life circumstances or whatever. And again, The Law Reform Commission said it should be defined as a measures that are or may be put in place to promote the health, safety and welfare of adults at risk of harm, including to minimise that risk of harm and to support adults to protect themselves. And the tools then for planning ahead and put in place. I won't embarrass people today to ask you to put up your hands. How many people have put in place an enduring power of attorney, an advance healthcare directive or a place of care decision? Think of your 87-year-old self. Where are you going to be? Do you want that application to court? Do you want the stress at that time? Really important that we take action now. So they're the tools that we're really talking about. They're safeguarding. So an advance healthcare directive is an advance, as the Act defines, an advance expression of will and preference made by a person with capacity concerning their treatment decisions that will arise at a time when they lack capacity. It's all about the right to dignity and bodily integrity. And we must respect everybody's right to that dignity and bodily integrity and not step in and make decisions on their behalf or make decisions that they would absolutely disagree with. The enduring power of attorney, which Anya has dealt with, again, it refers to the right to control over property and property affairs and the right to dignity. So again, that constitutional right. It does not include making treatment decisions and does not include depriving a person of their liberty. And then a place of care decision, and this is my own definition, is an advance expression of will and preference made by a person with capacity, setting out their preferred place of care in the event that they subsequently lack capacity. That's the right of personal liberty, a huge constitutional right. So the purpose then is to enable persons to be treated according to the will and preference, to ensure that healthcare professionals have that information. And again, the HSE consent policy recognises, obviously, a person is the best judge of their own quality of life. And again, very important for family members to have that information. So just where were we at in 2018 SAGE advocacy, and I know many of people are aware of this in terms of the next of kin. So you'll see there very high numbers, 57% felt they could make a healthcare decision on behalf of their family member. 54% they could make personal decisions, and 52% someone who could make decisions about the support of treatment to me. That hasn't moved very far since then. So huge numbers of family members think they still can make those decisions. Safeguarding Ireland has, over the years, and I've just pulled out some of them in terms of emphasising the planning ahead issues. We started Safeguarding Day 4 years ago, and every year we've looked at the planning ahead. So again, really important. I just put at the end there, the last one we did on financial abuse in Ireland, over 80% perpetrated by a person known to them. And for older people, that's a huge issue in terms of their money. And again, I see through SAGE advocacy, the cases coming through where somebody's appointed as a supporter and suddenly the bank account is cleared out or whatever. I see my time is running out very quickly, and I have a number of slides which I think are really important. So on place of care, again, 58% feel they can make a decision to put you in a place of care, even if you have capacity, but you may be old and frail. So really important. Again, in 2020, only 4%, the majority of people, this is a slide on the majority of people, we all know they want to be at home, and they put hospice before a nursing home or a hospital. So really important figures. In 2020, only 4% had a place of care decision, and only 4% had. Now, a place of care decision doesn't have statutory effect yet, but they had asked a family member. But in terms of an advanced healthcare directive, only 4%. Again, we did further research. Last year, just after the Act, and everybody here has heard of the Act. Last year, in May, we did a survey to ascertain how many people actually knew about the Act, heard of the Act or whatever. 83% did not know. That was less than a year ago. So we've a lot of work to do still in all aspects and by all professions. And I still hear awful situations. For example, again, to turn it to property affairs. The Land Registry and Tailteann still have on sound mind in their documentation. So you must certify that the person hasn't got on sound mind. This is 2024. The Act was enacted in 2015. So where's UNCRPD? Where's the realisation? A lot of state bodies, actually a lot to do. Earlier, when we did an earlier survey, we found only 6 or 7% on an ensuring power of attorney after some planning ahead, etc. Campaigns. That has gone up last year to 11%, but we're still at 4% in advanced healthcare directives. So again, this year when we were doing planning ahead, before we did a campaign on advanced healthcare directives, we found that a lot of people didn't know what they were. Only 4% have made an advanced healthcare directive. But very interestingly, only 4% of healthcare professionals had asked a person had they an advanced healthcare directive. And there are the reasons there in that slide where people thought it was too expensive. It wasn't, they didn't have a health complaint. They really never thought about it. So all of those reasons, we have a lot of work to do to make sure that when somebody appears in a hospital or a healthcare setting, that they're asked that question and actually it's in place. Again, the incidence of abuse and abusive behaviour as well as controlling behaviour. Just to say, coercive control underpins all types of abuse, and we have it limited in the domestic violence legislation. So really important that we understand that. Again, just in terms of accountability, training and education, and that is training and education for professionals in particular, and then family members. But just to say that the Department of Health last year, their digital health framework, which I absolutely welcome, they're saying a rollout of a patient app, and in 2025 a rollout of shared care records. Yet we still have no regulation in terms of the registration of an advanced healthcare directive with the DSS, which is absolutely required. So if you're in an accident and you're down in Cork and you live in Dublin, your GP is in Dublin, and your GP has your advanced healthcare directive, what use is it? So really we need to make sure that the systems that, and even where the legislation is providing for certain regulations, that they are put in place. So again, the whole question of the place of care decision, as I mentioned, we don't have statutory provision for that. That, again, the urgent enactment of protection of liberty safeguards to include a place of care decision, and the urgent enactment of adult safeguarding legislation. So in conclusion then, just to say that while a lot of progress has been made, a lot more work is required, particularly by state institutions and organisations, to ensure that that the prevention of abuse, their safeguarding policies and practices put in place, and the rights of each individual is respected, old, young, no matter what age, really important. And just to emphasise that the majority of people now that are accessing system or arrangements under the Act are older people. Really important that we recognise them and respect their dignity and whatever. Thank you.
Patricia, that was fantastic. I think a very clear exposition of how we can plan for our future care there. And just emphasising the point that was brought up earlier, this Act is about older persons' care as well as people with disability. And the majority of people who have been involved in the Act from a care point of view have been older people. The next person I'm going to welcome is Dr. Emer Ahern, who's a consultant ortho-geriatrician and a close colleague of mine. Emer is the National Clinical Advisor and Group Lead for Older Persons Care in the HSE and is leading on the development of the age-friendly healthcare system. Emer is also President of the Irish Gerontological Society, and having worked with her myself for the last 3.5 years, I can attest to her passion for the care and rights of older people, particularly in the healthcare setting, and Emer is now going to take us through a story on that. Thank you, Emer.
Thank you very much, everyone, and I'm sure I would probably have given up my time to listen more to Patricia, because every time I listen and hear her, I just learn more and more, and she truly is such an expert and an advocate, to learn from. So in response to Patricia's question, I do not have an enduring power of attorney. I do not have an advance healthcare directive. And I think it is important when we are planning how we fill that gap that we need to understand what that gap is and why it is there. And so this is a picture by David Hockney of his parents. And when I first saw this picture, what really struck me was the vibrancy of it, and really as an analogy to the vibrancy of the older person that I would like to be and the life that I would like to live when I am older. And I think when you think of that, and when you think of how people perceive, their lives and their quality of lives, there's a huge amount of evidence now for how that changes over our life course. So when I was 18, I graduated from UCC up the road. Not that I hadn't graduated, no, I wasn't that good. So I just finished at 18, so just finished my leaving cert. It was the day that I'd heard I'd got into medicine. I'd worked as a lifeguard on the beaches in West Cork for the summer, and I was using that money to go to Greece with my friends from college. So I was at the peak of what my life, of satisfaction with my life. It was never ever going to get any better than that moment in time. And that is true, and the evidence will say that, younger adults at that age have a really high satisfaction with their lives and a really high kind of self-perceived quality of life. And as you go on and as you start working, kind of getting mortgages, bills, families, children, that all changes, and actually it declines. So your self-perceived satisfaction and your quality of life actually declines. But what is really, really interesting, that it starts to rise as you get older. So people in their 70s and 80s will have a perceived quality of life and a satisfaction with their lives that matches me at 18 years of age heading off to Greece. And so with that then brings in the concept of an optimism bias. So that bad things will not happen to me, they will happen always to someone else. And that again is very clearly described in all the literature, and has really been described in older adults, especially in the context during the pandemic, and also during kind of major disasters, that people older adults will definitely perceive that they will not be affected by it, that it will happen to other people. And I think when we are working towards filling that gap between the advanced healthcare directives and the enduring powers of attorney, and how we move the shift to that type of proactive planning, we need to understand how people are perceiving their lives and their quality of lives, So I think that is just really important. So in preparation for the talk today, what I really wanted to do, and I was really struck and really kind of inspired by what I've listened to last night and today, and what I really wanted to do was really kind of talk about we talked about the spirit and the ethos of the Act. And I trained in my early days under Sean O'Keefe, and really he was a huge kind of inspiration and mentor to me that has kind of really stayed with me throughout my career in terms of that kind of presumption of capacity. And it's the only thing that I kind of really kind of goes through my head kind of every day when I'm dealing with older adults. So I work in CUH up the road, and what I do, I deal with older adults who have disabilities actually. So I deal mainly with older adults who come in with an injury, with trauma or an orthopedic injury, a hip fracture. So they come in with a new acquired kind of physical disability. It's often accompanied during kind of their stay in hospital by a mental disability as well, with delirium or depression or post-traumatic stress disorder in response to their injury. And they often have pre-existing kind of disabilities as well. So I work with older adults with disabilities every day. And what I really wanted to highlight was really the gap that there is between the Act, the spirit of the Act, and what's kind of real life kind of in working in the hospital every day. Because I do work in a state institution, and there is a gap, and there is a lack of awareness and a lack of knowledge. And it really is to try and again understand that and where we go to close that gap. So when you look at healthcare now, so modern healthcare is largely about the care of older adults. And this is just showing that older adults use healthcare more than anybody else. So they will attend their GP about 8 times a year. Over half of transfers in ambulances are in older adults. Most adults who come to hospital are sick. Most of the bed days in acute hospitals are occupied by older adults. They use most of the home support hours. And there's over 30,000 older adults who live in residential care. And again, here we'd have to ask the question, so how many of them have consented? How many want to live there? How many, have we got a human rights approach to this, kind of for older adults transitioning to residential care? So how many of them have been asked, when, and what I would ask is that at what age do you lose your right, to choose to live at home? At what age do you choose, to have your meals kind of served at a set time every day? So when do we lose that human right? At what age do we do that? And I would say, obviously, that we don't. And we need to have that human rights approach across the life course, across the continuum of life. And again, older adults benefit the most from the healthcare system. So the average age of having a heart attack is now 63, stroke 72. The first stage of a cancer diagnosis is now 68. Most people who break their hips are in their 80s. Most people who have a major trauma, it's not young men kind of crashing into walls or other cars or trees anymore. It's actually older adults falling. And most people who have emergency surgery are now older adults as well. So they benefit hugely from our healthcare system, but they are the people who are the highest users of our healthcare system. Yet despite that, and I was really struck by the comments last night when they were describing the High Court and Judge Dan O'Connor just in terms of their person-centeredness of the legal system. So a system that for me seems kind of like an antiquated, kind of bureaucratic, intimidating system. We talked about the building, the benches, that this has adapted itself, and the effort's been made to have that voice of the person really at the heart of the processes within the courts, to listen to that person-centeredness. And really when I was listening to both of them last night, I was really struck by the gap that this doesn't happen routinely in healthcare in our acute hospitals every single day. So a place where you would assume and presume it would happen, it does not happen. Because it wasn't designed to treat kind of like the people who are now kind of currently using the system. And that's associated with huge harm and cost. And when you think of older adults now, and when I often give this talk or talk about this, when I talk about older adults, they are a cohort that are at risk for harm because they have lots of complex needs. And I would say that this would apply to anybody who is vulnerable or marginalized for any reason, whether because they're homeless, because of mental health condition. So the same kind of principles apply. So there was a patient who came in recently kind of in under my care, and she was a woman who was living kind of with dementia, really well supported by her family and friends. And when she came in, she had broken her hip, and after her hip fracture was repaired, she became very, very sick and very, very delirious. And there was huge issues then around the time about whether she could return home or not. She had a really protracted time to recovery, and she wasn't been given the time or the access to rehabilitation to recover because of the pressures on the operational system within the acute hospitals. And numerous people had come and seen her and said she didn't have capacity and she had to go down this process and that process and this other process and she couldn't go home. And I was actually called to see her, and she was really clear. She was absolutely clear that she wanted to return home. She was clear about the support she had from her family and her friends. She was still delirious and needed kind of support and medical intervention to help her to get better from that. But mostly she needed time, and she wasn't being afforded that time. And with time, she actually did improve, and then we involved kind of SAGE, as an advocacy for her. But then she returned home and lived there. But I was just trying to illustrate with her case is that, when older adults come into hospital, bad things happen to them. They can become more disabled in hospital. They can decline functionally, they decline mentally. And the absolute wrong time to assess anybody in terms of their capacity to make any decisions is at that point in time. And every effort needs to make sure that we optimize their recovery before making any of those decisions. So we don't have a healthcare system that is designed to do that. So everybody in the room today who's working in healthcare, it is just really, really hard in that system to do that. And we need to focus, and I think, on older adults themselves and how to empower them to actually look for a system that delivers to them. And because the system isn't designed for them, harm is increasing for older adults. And I really want to kind of just speak finally about delayed transfers of care. So older adults will spend the longest in hospital, the longest days in the emergency department. I've said about 30% will get bigger. And the delays transfer of care, this is a list of people who, not by choice, but because we don't have services available to them, aren't able to leave the hospital. And there's lots of talk about people in there. And then one of the solutions that has been implemented for that is to transition people temporarily to nursing home care. And what we have seen is there is over 30 people leaving acute hospitals every day going temporarily to nursing home care, a place that doesn't meet their needs and doesn't meet their will and preferences. But this is happening kind of on a daily basis, day in, day out. And we recently had an example where I was informed of a young man with Down syndrome who had broken his arm, and his sister, who had been his support, had provided support for him, but she had recently died, and he was transferred to a nursing home temporarily while his arm was getting better. But 12 months later, he was still there. And that case was brought around to me. So again, we have implemented these processes to fix some other problem, but in actual fact, it's harming kind of people of all ages. And we've also got the highest institutionalization rate amongst older adults, mortality and readmission. And when I think of all this, I think of all the things we've talked about today is really kind of pieces of a jigsaw. So the Assisted Decision-Making Act is a piece in the jigsaw. You know, the courts are a piece, the legislation, the healthcare is all a piece. But overall, and I think kind of we've a huge amount to learn from the disability sector and that and their human rights approach and their advocacy and all the work that they've done, because we haven't learned that for older adults. But ultimately, kind of overriding all this, the biggest picture is that in our whole system, that ageism is really pervasive, so much so that we don't even recognize it. Where older adults they're less likely to be involved and supported in decisions about their own health and life. They're less likely to prioritize for health promotion and disease prevention, despite the evidence behind that. And they're more likely then in hospitals to be mistreated, undertreated, or overtreated, and less likely to be included in any research or education around this. So this is just another kind of picture where I thought was just really the dismay and the distress kind of by this person. You know, so older adults are coming into our state institutions at this time. We have a legislation that can support them, but how we actually kind of bridge that gap between the older adults kind of like receiving that support still remains. And that is, I think, where we need to kind of address this going forwards. Thank you very much.
So Emer, thank you for those real life stories. And I think it goes to show that we've done a lot, but we really have an awful lot more to do to get all those pieces of the jigsaw working properly together. I'm now delighted to introduce Sarah Jane Lavin, who's supported by Joan from Dara Disabilities. And just to briefly introduce Sarah Jane, her passion is advocacy, and she has had many avenues where she's used her advocacy skills. Sarah Jane is a board member with Inclusion Ireland and has completed work for the Housing Agency of Ireland. She's also a member of Dara's Inclusive Subcommittee and Advocacy Group and is involved with Selbridge and Clane access groups as well as Kildare County Council. Sarah Jane has taken part in many promotional campaigns, most recently for the HSE, in training modules for HSE Land. She enjoys education and is almost finished a QQI Level 3 in word processing and word publishing. Sarah Jane is going to tell us about why she believes it is important to plan for the future before introducing her video about her journey to independent living. You're welcome, Sarah Jane.
Thank you. Yeah. Good afternoon. I'm delighted to be here alongside Sarah Jane to present to you today. And we thank Elaine for the invitation. Sarah Jane is very much an advocate for herself and others. She, along with her mum and support network, very much saw the value in planning for the future and looking towards the future and what that might look like. I'm going to hand you over to Sarah Jane, and she's going to tell you a little bit about advocacy and some of the work that she does.
Okay, now, do I need to do anything? Okay, my passion is advocacy, and I have many avenues where I use my advocacy skills. Ward member with Inclusion Ireland, Dara's Inclusive Subcommittee and Advocacy Group, the Housing Agency Ireland, Selvert Sinclair and Access Groups, Kildare County Council, and the Citizen Support Service online training.
So you can see from that, she's a very busy woman with a very hectic schedule. So
Yeah. No.
Okay, so we're just going to talk a little bit about planning for the future. So can you tell us, Sarah Jane, a little bit about your journey and how you came to have a home of your own?
Well, my mother was getting old, so I decided I needed to go on the housing agency, to the housing
List.
list for the county council.
And how long did that take, that whole process?
That took about 10 years.
Yeah, so when you started to think
To
about
think
it,
about
have
it,
the conversation,
Chasing,
fill in the
fill out the
forms,
forms, and then we had to wait then for,
quite a while.
for quite a while. And then eventually, the Possibilities Plus last year and the council got me a house with my own apartment.
Yeah. And what were the important things when you were looking for an apartment or a
Well,
home of your own?
The housing list definitely, and filling in the forms.
Yeah, it's very
Because
important.
if I waited until the time came, then I knew it would have been a crisis, and I don't think I would have got my own choice. I would have been put wherever you can find a place.
Yeah.
Because that's usually what happens.
Yeah. And the key things for you are location.
Yeah, location, where I am now is grand, because I've got 3 different bus routes that will take me to different places.
Yeah. What
Lo-
else is in the local area?
All the shops, and then you've also got parks where I can walk, Castletown.
Yeah.
But I've got all the shops,
You've all the amenities. on
amenity
your-
centres, even my course is across the way now.
Yeah. And then you're gaining your independence.
And I'm gaining my independence. Like if I want to go for a walk, I can, or I can get on the bus and just, if I feel like going to a shopping centre, I can just go to a shopping centre.
Yeah. You're very much a travel expert on all the bus routes and train routes
Yeah.
around Kildare and Dublin.
I am.
And what supports do you currently have?
Well, at the moment I have, Sinead comes in, well, say, 3 days, like, a week. And then I have 1 evening support. But Sinead also comes in now on a Monday and a Friday. So you could say I have support 5 days a week.
A couple of hours each
A couple
day.
of hours each day. But I don't have any weekend support yet. But I'm working on it to try and get somebody to do weekends if I decide that that's what I want to do,
Yeah. Because currently you go home to mum at
Yeah, I
weekends.
go home to mum at weekends, but she is deteriorating,
Yeah.
You can see it,
Yeah.
You know what I mean?
Yeah. And so Sinead supports you with a couple of different things. So
Yeah.
what do you do with
Well,
Sinead?
I do, she helps me come in, helps me with dinner. And then if I need emails answered, sometimes if I don't, the ones I don't understand.
Yeah.
Plus, then if I need to be driven somewhere.
Yeah. And your many courses.
Yeah,
And
and
hobbies.
she helps me with my courses as well, and then my road therapy and that, we do that together.
Yeah.
But we also do the course together,
Yeah. So what course is that?
the QQI level 3. Like it was quite hard, but at least I persevered.
Yeah. You graduated last week.
Yeah, I graduated last week. No, I still have to do 2 more,
Yeah. Yeah. And just around the future, and what are some of the important things people should plan for?
Well, first of all, they should find out what's going to happen to them if their parents died. Because I've heard people say, well, I can't stay here on my own. I'm not allowed to stay in the house on my own. So I say, well, what happens when the time comes then?
Yeah.
We don't know.
Yeah.
I mean, that's basically the majority of people with disabilities don't know. If you ask them a question, what's going to happen when the time comes, most of them will either look at you as if you've sick head or just say, we don't know.
Yeah. And the forms can be complex.
Yeah, the forms can be very complicated. Although there's a new thing now that is the home support hub that people can go on to get the forms and that if it's easier.
Yeah. Yeah. And other things around planning for the future. So we talked about health and ageing being important.
Yeah, eating definitely is important because an awful lot of parents do get old, and for a person with disabilities, watching a parent get old can be very hard. You know what I mean.
Yeah. And for you now, as you age, you've got a lovely ground floor
So
apartment.
so at least if I did, hopefully I won't, but if anything should happen, at least I have that now to fall back on.
Yeah.
you know.
Education is very important for you.
Important, it is. Because unfortunately, my year of yesterday, I didn't get third level when I was in school. It was never heard of,
Yeah.
you know.
And also it's something that you need some support with, but there's many
Yeah.
out there who don't have that support.
Yeah, I do need support with it, but there's many who don't. That's why I'm saying these courses are great for people with disabilities, but if they're going to put them on, make sure that the support is there with them,
Yeah.
with it, you know. Because otherwise the tutor's going around on his own,
Yeah.
which isn't fair, because some of them will take up all his time. And so if you have 6 people and one person is required all your time, what's going to happen to the rest of the group?
Yeah. So certainly support is important, planning for the future.
Yeah.
Health and ageing, and for Sarah Jane, she was very much sure that she didn't want to end up in a crisis
What is the
situation.
situation? No.
And losing that choice and autonomy would be
Yeah.
very difficult for you.
You know, because somebody else would have decided, because that's what happens if people don't plan.
Yeah.
Somebody else could decide for you, and then you're not going to have any say in the matter.
Yeah. So we're going to move along now and play a video that Sarah Jane worked on with the Housing Agency, one of the many bodies that she works with.
Before here, I was actually living with my mother, which is the family home. That's where I've lived all my life with my mother until I moved here. So this, you could say, is the first time I've actually branched out. Because I think it's important to be independent. Because I'm more likely would have had to do this later on anyway. What happens to the person when the parents die, you know? It would have been a crisis then, whereas now I've done it. There is a mixture of people here. There's families, there's single people, there's disability people, there's everybody. I think it's good because then it means that we are actually integrated into the community. I still go up and do all my own things now. I can still get to my calls, but it's even closer. I would go down to the hub then on a Thursday because they have different things on. And then I can walk because there's the shop over there, then the shop's halfway down the village. And then if I want to go to a shopping centre, I can just get on the bus and go to the shopping centre now. I am actually happy. You know, all right, there are times when I say, well, but have I done the right thing? But then I say, no, you have, Sarah Jane. And of course, in the beginning, you're going to feel that way anyway. I was like, this is grand, you know, and it took me a while, of course, to sink in, you know, it still is like. But I said, as time goes on, it'll get easier and easier. There's been a few teething problems, but that was going to happen anyway. But I do have support to do it. The moment I have Sinead 2 days a week, well, 3 actually, and then somebody comes in 2 evenings a week. I'm getting there and cooking and doing my shopping and my bills and that. Now we're getting there, you know. But we need more of the right support. You know, that's what we're trying to say for somebody that's going in. The first thing I do is tell them to make sure they're on the housing list. And then secondly, make sure that they sort out what supports they need and the right support. And apart from that then, if they want to be independent, why not?
So a big thanks to Sarah Jane and Joan. I thought that was absolutely wonderful. And the take home for me there is the importance of the right supports for people. And I think that's what we need to do if we're doing person-centred care. And Emer brought that out as well. We need to think about what an individual's needs are and focus on what they tell us their needs are rather than us deciding what they are. And again, I think Patricia brought that out as well. Just a quick summary while we're getting this up here. I think our speakers have really given us a sense of the importance of planning ahead, that there are many tools that we can use to do that, enduring power of attorney, advanced healthcare directives, place of care decision making. And again, as Emer said, the right time is not when you're acutely unwell in hospital. If we have to do it, then it has to be done, but far better to try and get in and start planning ahead. Maybe a little anecdote recently just to show that I don't think we always do it. I was out with some friends recently, one of them also in the same business as myself, who was breathing a huge sigh of relief that her husband has made his will. So I said, well, and presumably you made your own at the same time. And she said, oh no, I'm not going to worry about that for the moment. I want to think about that because we all advise our patients to do their wills and EPAs. So really important to think about those things ourselves, as well as for the people we work with in health and social care. The next person I'm going to, I'll call up to speak is Caoimhe Gleeson. Caoimhe is our General Manager for the HSE National Office on Human Rights and Equality, but she's much more than that. Caoimhe is also a marvellous educator and has led the mentorship programme from ADMA and the HSE over the last year, and I can safely say I have never heard such positive feedback about any programme about a complex work that we need to introduce. It is a paradigm for how we introduce complex care like this. And Caoimhe has also recently been called to the bar. So we have two graduates here today, Sarah Jane and Caoimhe. Well done.
Thank you very much, and thank you to the inspiring Sarah Jane. Hats off to you, that was fabulous. I'd love you to be my advocate. You're fantastic. So I'm going to talk now about a friend of ours, Dr. Fiona Morrissey, who sadly passed away this time last year on the 12th of November, surrounded by her beloved husband Mark, her family in County Galway. And I'd like to acknowledge that we're joined by Mark online, by Fiona's mother Claire. I'll try and just get through this, and Fiona's father Jerry. And our best wishes go to them as they kind of get through these days and weeks together. I'd also like to acknowledge that her friends are in this room. There's a number of her friends that are in this room, and there's a number of her friends that have joined us online. So I think her family would be really kind of pleased with the support that she has in her absence. So for those of you that don't know Fiona, she was a human rights advocate and activist whose research work focused specifically on mental health advanced healthcare directives and how they can protect and preserve a person's voice and dignity, particularly at times when they are acutely unwell. Fiona was a graduate of the doctoral programme at the Centre for Law and Disability Policy, and we have some colleagues here from there today at University College Galway. Her PhD focused specifically on the introduction of a legal framework for advanced healthcare directives in mental health care. That was her specific focus. Much of her research focused on the importance of mental health advanced care directives for the preservation of the voice and dignity of the person. She had extensive knowledge of the Irish mental health law. She was appointed by the Mental Health Commission to the Mental Health Tribunals as a lay member. She was a member of the Advanced Healthcare Directive Multidisciplinary Group under the Assisted Decision Making Capacity Act to draft the Codes of Practice. Throughout the drafting process, and there's people here who were part of that drafting process as well, they will remember Fiona always pulled the discussions back to the voice of the person. Do not forget the voice of the person at all times, and be absolutely faithful to the provisions of the UNCRPD, the United Nations Convention on the Rights of People with Disabilities. She was a member of the Legal Capacity Coalition. Again, we've got members of this group in the room and online, which was a coalition of activists, experts by experience, and NGOs who provided multiple submissions and observations on the Assisted Decision-Making Capacity Bill as it was going through the Oireachtas prior to its enactment in 2015, which is 9 years ago, just to point that out. She remained a tireless campaigner to amend the exclusion of people who were involuntarily detained from making advanced healthcare directives for their mental health treatment in the 2015 Act, and she was involved in a number of private members' bills, Dáil debates, and Oireachtas hearings to amend this exclusion. Fiona provided ongoing advice and guidance to our office over many years on issues relating to advanced healthcare directives, do not attempt cardiopulmonary resuscitation, which is called DNA, CPR, and advanced planning. She was a regular subject matter expert on our webinar series on the preparations for the commencement of the Act. She's on advanced planning in COVID-19. She specifically helped us in relation to a do not attempt resuscitate amendment, and on the development of our e-learning programs. She was one of our main subject matter experts. She was an advisor on the development of a standardised template for an advanced healthcare directive, which is now available on the Decision Support Service website. Fiona's research explored the cathartic effect of a mental health advanced healthcare directive. 78% of the participants that she surveyed in her research who had been involuntarily detained under the Mental Health Act wanted an advanced healthcare directive to provide control over their future treatment options. And this is quite different from other advanced healthcare directives. They wanted their advanced healthcare directive to provide a forum of dialogue and exchange of information. Her research evidenced that mental health advanced healthcare directives provide a forum for reflection where a person can articulate their values, reflect on their past healthcare experiences, and identify their future wishes. Throughout her extensive analysis of other jurisdictions, Fiona's research showed that mental health advanced healthcare directives can promote trust and respect, leading to enhanced outcomes. She further evidenced the research indicating that mental health advanced healthcare directives are rarely used to refuse all treatment. Often they contain clear, valuable information consistent with clinical standards. It's encouraging to know that many of the themes addressed in Fiona's work will be examined in a national conference in January 2025 in University College Dublin, which is dedicated in its entirety to the application of advanced healthcare directives in mental health care. We are so grateful that we had the opportunity to work with Fiona, and we miss her passion, humanity, and dedication to human rights. Bear with me again. We're also very grateful that we have a record of Fiona's work with us. She wrote a chapter in our book, The Assisted Decision-Making Capacity Act, Personal and Professional Reflection. She's a beautiful chapter in that book, and I'd encourage you to access that on our website. We also have some amazing archive footage of Fiona talking about these issues. And I'm delighted that we actually have, fingers crossed, we have an extract from a live presentation that Fiona gave 5 years ago in Cork on the importance of advanced healthcare directives, particularly in the context of mental health. And you'll see that her words and message remain as important today as when she delivered them 5 years ago. Fiona's legacy clearly lives on, clearly continues to live on, and I think it's fair to say that her efforts in laying the foundational cornerstone, upon which new work on advanced healthcare directives is being built, and it's a testimony to her legacy. So I'd now like to hand you over to Fiona, who's in the room with us today, so thank you.
Caoimhe and Mary for inviting me here today, and I'm going to call person rather than patient. Sorry, can everybody hear me okay? And somebody in the States said to me, just on those comments Alex made, the bull looks different inside the ring, and that's, I suppose, can apply to advanced healthcare directives. But just to start, I just want to have some comments to think about all our lives and ourselves, how we put ourselves into this situation. I want you to imagine for a minute if somebody was making decisions for you, that they could decide to take you away, lock you up, not listen to you, and give you medication, block you from doing your work and living your life the way your body and mind are now. Would you want that to happen to you? And wouldn't you feel that you'd lost your dignity and want it back? And that was a quote from the drafting of the UN Convention on the Rights of Persons with Disabilities. And it's really, I suppose, to reflect on our own lives and put this back, to ourselves. How would we feel if we were in these situations? So any of us can be in this situation at any time. If we're in a road traffic accident, we get an acquired brain injury, we have a stroke, we develop Alzheimer's, we develop a mental health condition, which 1 in 4 of us do during our lives, experience mental health difficulties. At that stage, we might need an advanced healthcare directive, and we're vulnerable. All of us are vulnerable to losing our capacity, and I think we need to remember that. And it's at that time in our lives that we're most vulnerable to being abused. So why are advanced healthcare directives important for all of us in this room? And as I said, any of us could be in that situation at any time in our lives. And we're all potential users of mental health services. And that's a quote from the UN Rapporteur on the right to health. And he says, we are all potential users of these services, and we're all vulnerable to losing capacity. If we don't plan or have an advanced healthcare directive, someone will make those decisions for us. And who will make that decision? So our next of kin have no legal authority to do this unless we're in wardship. So when this happens, people lose control over their lives, and they have that can be very damaging for the person. You know, treating someone against their wishes can cause additional trauma to the person, which they then have to recover from. I did a piece of research here in Ireland with service users and consultant psychiatrists, and I found that there was a breakdown in family and therapeutic relationships where people were treated against their wishes. So we need to think about that, how we plan, who will make those decisions if this happens to us, who would we trust in these situations. So advanced healthcare directives enable us to continue to have a voice in our own care, allow us to outline our treatment preferences, our mental health treatment preferences in a legal statement, and to appoint a trusted person to communicate our wishes. So the trusted person is critical here. Someone that we have discussed our values with. We've had a conversation about our life values. As instructions alone sometimes are not enough. So we need to think about who would we trust in this situation to communicate our wishes if we were to lose capacity. So really, I suppose it's about having healthcare treatment in accordance with your wishes, and it's about respecting the voice of the person. And I'll say person rather than patient, and I'm glad you said that. And that's better for all of us. So I want you in this room today, everyone in this room, to think about if you were in an accident or you became seriously ill and you couldn't speak for yourself, who would you trust to make these decisions? Would your family and friends and people around you know what you want? Would they know what you wouldn't want? And it should be someone you trust, if you have someone you trust, and not everybody does, and who is capable of making decisions based on your wishes, even if they don't agree with you. So that person has to be able to make decisions even if they don't agree what your wishes and values are. And sometimes that person may not be your spouse, and actually there was a piece of research done which shows, people's spouses weren't always the best people to make these decisions. So the situation in Ireland at the moment is that fewer than 1 in 10 people have actually discussed their future care needs with their family and friends. Few people have nominated anyone to make decisions if they were to develop a serious or long-term illness, and only 11% of people actually knew what an advanced healthcare directive was. How many people in this room before they came here today knew what an advanced healthcare directive was? I hope one. Obviously not representative of the general population. How many people here actually have an advanced healthcare directive? I know Patricia definitely has one. Well, that's not bad.
So that was great, and I'm not sure if people are aware of a lot of evidence from the UK that advanced healthcare directives in mental health reduce the number of involuntary admissions that individuals have, they reduce the length of stay for involuntary admission, and they reduce the level, they reduce the kind of care that people get during involuntary admissions and improve therapeutic relationships. So that evidence is really emerging very strongly from the UK, and it's something we need to very much consider and look at and encourage here in Ireland. So I'm going to ask all our speakers to pop up on the podium now, and we're going to have a Q&A session. And joining us, we have Aoife McMahon as well, who's dual trained in law and business administration and is also head of registration in the Decision Support Service. So if everybody could pop up there and we'll have a Q&A. So I hear we've got a pile of questions coming in, and I hope we can do our best. Caoimhe, will we go to the ones that are coming online? Because I see a couple of hands up around the room as well.
Okay, so how do you have to appoint a person to make your do you have to appoint a person to make your healthcare decisions on your behalf?
Okay, folks, Patricia.
So you can make an advanced healthcare directive by writing out your will and preference. You don't have to appoint a person, but the Act provides that you can appoint a healthcare representative to make decisions on your behalf and to consent or refuse treatment. It's also important to say that while under an enduring power of attorney, you can appoint more than one person to be your attorney. Under an advanced healthcare directive, if you are appointing somebody, you appoint a single individual to make your decisions on your behalf in accordance with your advanced healthcare directive. So it's really important to have that discussion if a person is being asked to be that healthcare representative, that the discussion takes place and is ongoing, and the directive is reviewed from time to time.
Okay.
Thank you. But
So,
Quivi, yeah?
if you want a few of these and then maybe from the floor then?
Okay, we'll do it, yeah.
Okay, so under the 1996 Act, I could complete an EPA in 6 to 8 weeks. It's now taking multiples of that time. What can the DSS do to improve the speed of delivery, considering diminishing capacity is often a feature and the need for timely service delivery is crucial?
Anya.
Thank you. I'm on. And we do hope, I suppose, that EPAs aren't being made at a time when people have diminishing capacity, but acknowledging that that is real. I have mentioned examples of where we've been able to assist in expediting the making of EPAs, so I would reiterate, please make contact with us. Thinking about timelines, and they were too long, they are correcting. I think currently we are looking at digitally submitted EPAs fully completed and sent to us, and obviously 5 weeks notice period needs to elapse. We're currently looking at EPAs submitted in that fashion from late July, August, we're up to August. If we look at the ones that were submitted manually, we have not a help desk, we have a help desk, and that's certainly helping. They've answered more than 2,000 calls in the last month. We also have a backlog team that we were able to put together to address those manually submitted EPAs as well. And then overall, we do need to keep, as I said, our processes under review to try and make everything more straightforward and to shorten the process as far as possible. But I think it would be helped if people recognise that leaving it off is not good because we would possibly face into those urgent or emergency situations. So that's why with our current campaign, we're encouraging people to see advanced planning as something you do right now.
Okay, thank you, Anya. Quiva, do we have another one?
Yeah, we've the kind of truncated. So where is the rights-based approach from moving people out of hospitals into nursing homes? How is that a rights-based approach? And also, where is the statutory home support scheme? Where has that gone? Has that fallen off the government agenda?
I think I might just come in a little bit on that. So I'm not entirely sure what somebody means by is it a rights-based approach to move people out of hospital? But I do think we're being very much more careful now to make sure that to assess people's will and preference before they move, bearing in mind what Patricia always says, we assume capacity. Emer, do you want to come in at all on that one?
Yeah, I suppose it isn't a human rights-based approach, what we're doing, but I suppose it is about ensuring, and we certainly are working, to try and ensure that that process kind of aligns with the principles really of the Assisted Decision-Making Act. And also we have the nursing home kind of support scheme, which again has been trying, which is older legislation, trying to kind of marry and align with kind of this new legislation. And that's just been difficult because as kind of test cases are going through the courts, really, there's learning kind of with each iteration of it, so it isn't something that you can just kind of sign off kind of straight away, it has to be done in consideration of cases as they're going through. So I suppose it really kind of gets back to kind of looking at the process, and the original process with nursing home was kind of to have a comprehensive assessment and to assess your will and preference and for the person to consent to it. So there definitely are elements that support the ADMA in that process, but we probably need to get better, and certainly better in terms of that temporary transition of people to nursing homes as opposed to the permanent transition.
And I think fair to say that the nursing home support scheme is still in place.
Yeah.
Patricia, did you want to come in there?
Just to come in on the point that at the moment, the Department of Health are looking at the whole issue of protection of liberty safeguards, which is fundamental really to this. And there was a bill published in 2017, and that was put on hold during COVID. And obviously today we heard that a number of people are part of that advisory group, and the plan is to have to introduce a statutory authorisation process, but really importantly, the first issue is the assessment of the need, etc. Next thing then is the will and preference, and if the person decides themselves has capacity, even with support, and their wish is they want to be at home or they want to be in another place, then that must be followed. And then there will be, if the person lacks capacity, that authorisation process will come into effect. And again, following the principles in the Act, which is really, really important. My understanding on the home care, just to say, the Law Reform Commission made its recommendations on the regulation of home care in 2011. And again, I emphasise this is 2024. And I know HICWA at the moment, they have done some work on looking for submissions on home care standards and regulations, and hopefully we'll see that in the very near future. So again, we're going to have more, I suppose, statutory provisions in terms of ensuring the rights of an individual are put into effect and respected.
Thank you, Patricia, and ensuring that those statutory provisions are aligned with the principles of the Act.
Absolutely.
Not the key.
Yes, absolutely. And
Yeah.
they both will be drafted to comply with the principles in the Act. Yes.
Excellent, that's great. I'm going to open it to the floor, and there's somebody back there. So can I ask if anybody wants to ask a question, just to introduce yourself?
Hi, my name is Valerie Smith with Irish Hospice Foundation, so I know many of you, but thanks for answering that question on the statutory provision around place of care. I might follow up with you on that. I have questions what that might look like, but also wondering, a lot of the questions that we get would be people who would like to name somebody a supporter and don't have someone that they trust. And I wonder, is there provisions somewhere where people can record preferences around care generally, either financial decisions or other things, without naming somebody, but how they would like to be looked after without naming somebody? Is there thoughts or ideas from the audience around that?
Well, even in an advanced healthcare directive, you don't have to name an individual. So you can set out exactly what your will and preference are, and I would maintain the same for a place of care decision, and we need to get into that practice. So it's really, really important. It's the will and preference of the person. And even if you do nominate a designated healthcare representative, that person may lack capacity in the future, may have died, predeceased you, all of the rest. So really important to set out your will and preference that obviously then must be followed through on and acted on and respected.
And I suppose just to add to that, I think isn't it important as part of all of our clinical and health and social care interactions to note people's will and preference in the chart as well, or whatever your medium is when you're seeing people. I do think that's very important, even if people don't have their AHDs in place, that when we're seeing our people who attend our services, that we listen to what it is they want and document that. And that can be done. That's a longitudinal process as far as I'm concerned in all of our health and social care interactions. Is there anybody else from the floor? I see somebody back there.
Thank you very much. Fiona Bernachus Anam Dom, and just to thank Quiva for the lovely tribute to Fiona Morrissey, who's a dear friend and fellow advocate. I just want to speak about Article 5 just for a minute, Article 5 of the UNCRPD in relation to equality and non-discrimination provisions. Article 3, equality and non-discrimination, comes up in terms of principles, and Article 5 in terms of rights, and there are immediate obligations there, regardless of the reservations and declarations that the Irish state has placed, shamefully placed in terms of the convention. And I would hope that Justice O'Connor and the various judges would reference the UNCRPD in their judgments, regardless of these functional capacity assessments, that the state has conflated mental capacity and legal capacity. And I think that's something that Fiona Morrissey really spoke, and the Centre for Disability Law and Policy and the Civil Society Coalition in relation to that, and that they are discriminatory, and that it's a cross-cutting article, Article 12 and Article 5, that they interlink. And I think what worries me particularly around the implementation of the Assisted Decision-Making Act is that parallel to this we have the psychiatric system, where we cannot actually speak about what we're doing to people who are detained under Part 4 of the Mental Health Act, and also people who experience neglect. But just to confirm that the Act further enshrines and perpetuates that discriminatory aspect. You know, that people, when they are deemed to have capacity, and I would say deemed, not that they have or don't or lack capacity, but they are deemed to have capacity. And even if they are deemed to have capacity today and make an advance directive, I do not ever want to have electroshock, ECT, that they still can be subjected to that. And I think Niall and the department and the College of Psychiatry, the Mental Health Lawyers Association, mental health lawyers, the judiciary, really have an obligation to step up in relation to this, because from civil society we were blocked at every level advocating. And we further enshrined and perpetuated discrimination with this. And one thing Fiona Morrissey always said, that anybody could come under the provisions of Section 4 of the Mental Health Act. We have a regrading clause in the Mental Health Act. Anybody can present in a voluntary capacity. And sometimes situations are orchestrated so that somebody ends up in that situation. You know, because then the psychiatrist doesn't have to have the conversation around consent to treatment. They can pretty much do what they want. So Ireland in 2024, we still do that to people. Violence against women, we don't hear any of the organisations advocating in relation to that discuss what we are actually doing to people. You know, and regardless of what's in the Act, the UN mechanisms provide an opportunity for civil society to present to the UN in relation to what's going on. And hopefully IREC will actually step up, because I'm very disappointed in what they're actually doing in relation to these violations.
Fiona, I think you've put some very challenging thoughts there for our speakers this afternoon. I just want to take this opportunity to thank our fantastic speakers at this session about advanced planning and how to look that the time to start advanced planning for our own healthcare, health and social care, is now. And that's the take-home message for us. The other thing I think we can take out of what Sarah Jane has talked about and what Emer have talked about, actually a health and social care system that is age and disability friendly is a health and social care system that will benefit every single person, because nobody wants to sit in an environment that is loud, that is noisy, and that challenges them when they are not well and need our health and social care.